Welcome to the INREM podcast, where we discuss the law for real estate investors. Andy and Sean are both attorneys. Nothing said in this discussion should be considered legal advice. We're simply providing information and education. You should consult with an attorney in your state regarding any specific legal issue that you may have. Hey, everybody, welcome to the show. Today, our topic is working with closing attorneys on creative finance transactions. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to like the channel. You can find us on Facebook. You can find us on YouTube. If you're not on YouTube, go over there right now. You can find us at INREM Podcast. That's at INREM Podcast. Subscribe, follow our content. We'd be happy to continue producing more for you. With that, we're going to go to Sean, who has our legal update.
So today, Andy, I want to talk about a topic that's related to last week's legal update, which dealt with operating agreements. But this time I want to take it a step further and talk about buy-sell agreements. So what is a buy-sell agreement and when should you use it? So a buy-sell agreement is basically a prenuptial agreement for not real estate investor, for business owners. So it's a prenuptial agreement for business owners. And it basically lays out the circumstances by which an owner may withdraw or be withdrawn from the company. We call it in Arizona dissociation. That's the legal term we use in Arizona. But when can they withdraw or be dissociated from the company? And when they are, what does that look like? So your common events for a withdrawal or dissociation are first, just to voluntarily withdraw. Say, hey, I just don't want to be in business anymore. I don't want to do this anymore. I want to withdraw. So that's number one. The second would be a withdrawal or a termination for cause. So a dissociation for cause, meaning that member has done something just so horrific towards the company. You know, they've embezzled, they've stolen, they breached their fiduciary duty towards the company, and as a result, they're terminated or they're dissociated for cause. The other scenario would be a situation where, and it doesn't work too well when you have owners that are 50-50, but let's say you have three owners, and two of the three owners realize we just can't be in business with the third owner. Like, we just don't work well. They didn't do anything wrong. They're not a bad person. Business-wise, we just don't see eye to eye.
Oil and water.
Yeah. So, in that case, that would be what we call a member-voted dissociation or a member-voted termination or withdrawal, where the other two members basically vote and say, yeah, we can't be in business with you, so we're going to dissociate you. We're going to remove you from the company. But there's a fairly hefty buyout, and that's what the buy-sell does, right? The buy-sell says, okay, well, in that situation, here's how you pay for this person's membership interest, and here's how you value their interest, and here's what they're owed and when they're owed it. But you can, if you structure your buy-sell correctly. Then your other scenarios are your three, D's, if you will, the big D's, the divorce. So divorce can result potentially in a withdrawal or dissociation. All of a sudden, you're in business with somebody and their spouse now, because of a divorce, comes and claims a right to the company and the right to, membership rights and the ability to vote and participate. And you're like, wait a minute, I didn't, want to do business with this spouse. So in that case, for purposes of the buy-sell, you can have a provision in there saying, hey, if one of the members ends up being divorced, then we have a right as a company to basically buy out the entire membership interest, whether it's controlled or owned by the member or the member's spouse or X. Then the other D would be your disability. A member is disabled. They cannot participate in the company anymore. They are no longer able to pull their weight because of a disability. And so you can have provisions as to what that looks like. Now, disability, you can pair the buy-sell with disability insurance, which provides a return or a payment to the company so that they could find a replacement for that person. If they're no longer able to pull their weight, then you can use that money to replace them, to employ somebody. And then another portion of the disability payment can go to compensate the member who's disabled. And so you can pair the dissociation provisions for disability with disability insurance and have that reference in the buy sell, and you decide in advance how to divvy up those monthly payments. And then the final thing is death. What happens when a member dies? And in that case, like disability, you can pair that with life insurance, a portion of which goes to the company to basically fill in the gap that's left behind by that deceased member. And then a portion goes to basically buy out the deceased member's estate or heirs of their interest in the company. And so that's in essence a buy sell. It's basically you have owners of a limited liability company generally. You could have one even for a corporation in conjunction with like a shareholder agreement. But basically, it is a prenuptial agreement. You enter into it before any event comes up, and you try to anticipate the different events that could result in the separation of the owners of the business and what it looks like when that separation happens from a financial perspective. I think it's important for most businesses to have a buy sell in place, because the last thing you want is to build and develop a business that's a good going concern, only to have a dispute between the members ruin the whole thing, or only to have one member pass away and you don't have the financial resources to continue on, or for a member to be disabled, et cetera, et cetera. So it's important to, in my view, to put it in place. I recommend it anytime you're going into business with somebody else, because in essence, when you go into business with somebody, it is almost kind of like a marriage relationship, right? I mean, you're a lot of times spending more time, as much or more time with them, as your spouse even. And so it's important to have that in place, to know what it looks like for the separation of owners to happen while still hopefully able to maintain the business and the value of the business.
I think the common mistake a lot of business owners make with buy-sell agreements is the same mistake that they make with their own estate planning, and that is that they think it only matters if they have a lot of money, or if, in the business context, if their business is got a ton of money and is huge, right? And they think that if it's not that, then I'm just wasting money, I don't need this. And in reality, take the money aside. If somebody dies, that business comes to a halt. This may be even more important than in just the personal context of estate planning, because oftentimes you're married, your spouse is on accounts and they can take over. But ABC LLC on whatever bank account or wherever else is what the financial institution is going to recognize. And if that person's not there to sign those checks or to give their ID to that bank, effectively it's shut down until you can fix it. A buy sell and a proper operating agreement, all that work together fixes all those problems, right?
Exactly. And we've seen clients who are in the middle of a business dispute where they've basically gone to the financial institution and tried to transact business, only for the financial institutions to say, oh, no, there's a dispute among owners. We're doing nothing. And it makes it very difficult for that company to continue doing business, because they freeze the accounts in that case. If they find out that there's a dispute among members, they don't want anybody tapping into those accounts. They don't want anyone accessing it for fear that they're going to somehow be dragged into some type of liability for allowing one member to zero out the accounts, to the disadvantage of another member.
Yeah, and that's all in the clauses that you ignored when you signed up for the bank account. That bank has incredible authority, and if you don't wanna be basically at the whim of a third party as to whether you can transact business anymore, put the documents you need to in order on the front end and make sure it gets done. Whether the business is worth $50 million or not is a whole 'nother question, but not itself the sole reason you do a buy-sell agreement. All right, good information, Sean. With that, we're gonna get into our topic today. Our topic is working with closing attorneys on uh, real estate transactions. And our guest who's joining us today is Bree Rials. Bree is the managing attorney at the law office of Bree Rials, LLC. Bree, thanks so much for joining us.
Thank you so much for having me.
So tell us about your law office, about your practice, and how you got into it.
Okay, so I am working in Illinois primarily at this time, and I'm just made an announcement a few weeks ago that I'm going to also be opening an office in Texas as well later this year once I'm licensed in
Congratulations.
Texas. Thank you so much. In Illinois, I am primarily handling residential real estate transactions in which I represent buyers and sellers. So either people purchasing a home, investors that are purchasing properties, and then people that are selling their homes, whether as investors or even just someone doing their first transaction, selling the home because they're either relocating or growing their family or for whatever their needs are. My practice is fairly new, and I've just been very, very, very appreciative as how much it's just boomed in the last few years. I started my business as many did coming out of COVID, having trained under one of my mentors prior to who actually was the attorney who closed on the home that my husband and I bought. So I was working under his supervision and learning and training with him. He's actually in the west suburbs in Chicago, which is where my family and I just were purchasing a house at the time. Learned under him and then had to push, like I said, with COVID, as many entrepreneurs or now business owners did, to go ahead and start working for myself. So I was able to launch my firm and do that starting in 2020, coming out of 2020. And it's been really great so far. I really get a lot of joy from working with from first time homeowners even to seasoned investors and people that are constantly in the business of buying and selling. So we are a virtual firm at this time. My staff works virtually and myself as well. As I know I spoke with you and Sean about, I'm just coming back from maternity leave. So having that flexibility, being able to do a lot of things virtually and communicate with my clients, even as you and I are communicating now in this 2022 era, post COVID times, has really been phenomenal. And they've still been able to get great access to me, access to my staff, and of course, be affected still efficiently and effectively, represented efficiently and effectively.
So, an entrepreneur and a mother. I'm surprised you took the time to talk with two old boring guys like us, but we do appreciate it. We know you're busy. So closing attorneys are kind of a novelty to Sean and I. We come from the state of Arizona, where we don't have closing attorneys. I went to law school in the state of Virginia, and when I moved there from Arizona, I was first introduced to this idea that okay, on closing on my home when I was there, I had to go retain an attorney to close the deal, and I thought, "Well, what's going on here? I don't need an attorney, and I don't wanna pay for one." That was my thought at the time, but, um, the so that was kind of a new concept for us, but we wanna talk about that because a lot of the states that, we have contacts with and interview folks in have closing attorneys. So, why don't you, for our listeners that are watching that might be real estate investors maybe here in the state of Arizona that are branching out into other states and are trying to learn what's out there. Explain for us and them, what is a closing attorney?
So, a closing attorney, I'm sorry about that. A closing attorney in Illinois, which isn't a state in which it's not required, but it's typically advised and it's traditional for a closing attorney to be used, is one who acts as they're there to be your protection from the beginning of the transaction until you close. And that means that we review the contracts. We even are able to, in Illinois, negotiate the contract. So in Illinois, we have what's called, in the most traditional contract that's used, an attorney review period. And what that does is, for a buyer, for a seller also, it allows them to get their contract over to a closing attorney in Illinois, which is typically a real estate attorney, to allow them to review the contract and make sure that the terms are favorable. So if you're a buyer, of course, you want to make sure you're getting into a deal that makes sense, in which you're well protected, and all the terms are going to make sure you're not running into or hitting any bumps down the line, and you're not running into a lot of different things that could have been caught had you had an attorney be able to review the contract. So one thing, for example, that's been a big thing this year in Cook County, which is one of the largest counties in Illinois, there was a reassessment this was a reassessment year, so the taxes changed. And realtors, while they help the buyers go under contract, meaning they typically draft them, and at the point that I get the contracts, they've been executed, which is why this 5-day attorney review period is so great, because it allows the buyer and the seller's attorney to renegotiate terms of the contract if they've read the contract and decided that a term or there was a provision that wasn't favorable to their client, then they're able to request a modification. And that's what this attorney review period is for. And it's so amazing because, say, for instance, one thing as an attorney that represents buyers as well is I make sure that they have proper tax credit from the seller at closing. And with this having been a reassessment year for Cook County, then we want to make sure that that proration is calculated at the proper percentage rate, or we negotiate that there's a holdback possibly from the seller to have funds tucked away so that my buyer is then not responsible for paying taxes that were during the seller's ownership, which essentially the seller would be responsible for paying. We're able to even make nuanced modifications if necessary. If, say, my buyer maybe went under contract as a single person and they wanted to add a parent, or they wanted to add a spouse, they were able to negotiate those in the contract, and we're able to just use language that allows additional protections. So a lot of times attorneys, some of the modifications that we request are not necessarily changing terms of the contract, but we're able to supplement and add additional layers of protection for our clients during this attorney review period. So that's the initial great benefit of having a closing attorney, is having someone with the legal knowledge, with the real estate background, to be able to look at your contract and say, hey, here's where the deal really works out for you. Here's what we want to request a revision or modification for. And then that attorney goes through the process of the entire transaction with you, meaning that my office and we request extensions as necessary. If we need to extend a contingency in the contract, then we're there to be the liaison between the other side of the transaction, whether it's the seller side or the buyer side, to make sure that at all points we want to have the client's interest be protected. And one of the biggest things everyone wants protected in their transaction until we close is their money, meaning the earnest money that they put down. And the only way to make sure that this is protected is to make sure on my end that I am not missing dates or deadlines, and that I'm abiding within the terms of the contract, to make sure if for any reason the contract falls apart, my client is able to retain their earnest money back, or my seller has a remedy to protect themselves for loss of time on the market or different things that they would want as a remedy in the event that the contract falls apart. So you want to have an attorney making sure that your legal interests are protected. And as a buyer, one of the biggest things that I do for them, which is really obviously the biggest moment of the transaction, is I'm there to represent them for closing and explaining the documents. Once we've gotten through the contract modifications and revisions, if any were necessary, once we've gotten through making any repair requests and negotiating those on their behalf, and once we've gotten their loan approved, and then even reviewing the loan commitment to make sure that it is in compliance with the contract, we get to the fun part everyone's waiting for, getting the keys. So at closing, then I'm there to make sure that the buyer has full understanding of the documents that they're signing and what's essentially going to be the biggest transaction of their life in many cases, as I represent a lot of first-time home buyers, making sure that they understand what they're to do after the closing. And even I avail myself, after the closing, if they need to reach out, if there's anything that comes up. But my job is to make sure that nothing does come up after closing. Reviewing the title commitment, making sure they're getting clear, clean transfer of title. The seller has complied with everything on their end to make sure that that's been effectuated. So in Illinois, on the seller side, when I represent sellers, I am the title agent, meaning I'm ordering title through the title company, and I'm the one to make sure title is clear. So any encumbrances or deficiencies that are on title, I work with the seller to make sure that we get those cleared, and then in turn are able to transfer and give marketable clear title to the buyer.
So, Bree, you mentioned the that it's optional. Having a closing attorney is optional in Illinois. Did I hear that right? Okay. So it sounds like you might have, well, let me ask you this. What is your sense? Is it basically common practice that most people in a real estate transaction retain a closing attorney? What would you say? 50% of the time, more often than not?
So for Illinois, I've learned it seems to be like a regional thing, even within the state. For the 5 collar counties, which is Cook, and then the counties right immediately outside of Cook, it's very common practice. Your agent typically will refer you to work with a real estate attorney, because I've heard otherwise in other states, of course, that it's not common practice for a real estate attorney to be used. But the agents, and I'm leery when I do hear this, because they're not equipped typically with the legal background and knowledge that we are as attorneys to educate and advise, and then even to negotiate these different things that we may need to request from the other side. In other states, I know that's typically how it's done, but in Illinois, with the attorneys typically being the title agents, it's within the 5 collar counties. Like I said, most commonly a closing attorney is used. I have had other clients that have reached out to me from counties that are further out, like in Rockford, Illinois. I've had clients reach out where it's not common for them to use a closing attorney. So I've learned, like I said, just in my experience so far, I've learned that further out, maybe in other areas of Illinois, it isn't common practice, but generally in the metropolitan areas, it is more common for a closing attorney to be used than not.
Bree, I want to go back to this attorney review period. I'm fascinated here with that. We don't have that here in Arizona. In fact, there's a lot of discussion right now in the investor community, especially on like creative finance transactions. There's certain states, Colorado being one of them, that if a property's in foreclosure, you have to provide the seller with a 3-day right of rescission. So they have 3 days to think about it. So it sounds like in Illinois, there's a 5-day attorney review period. And so does that apply to both the buyer and the seller? So they enter into a contract, and then is it by operation of law that they receive the 5 days to have an attorney of their choice review the contract and decide whether or not to, proceed forward?
So in Illinois, when the counties, like I said, that I work in, that is by operation of law in what's most commonly used in traditional transactions, which is the multi-board 7.0. That it's in paragraph 10 where we have this attorney review provision. But if you're doing a transaction outside of that contract, maybe you're not using the traditional form that, let's say you will, form, then you might not have that included. And I've seen that before. And if I've gotten the contract, hopefully before it's been executed, then that's a clause that I would want to manually have inserted in. But in the standard traditional form contract that most realtors use, that the associations provide, the 7.0, that is written in there. And it does have, like you were mentioning, the rescission period. So your attorney can make modifications within that period, or they can declare the contract null and void. So like I said, it's similar to that rescission period. And either buyer or seller can get out the deal within those 5 days, simply by their attorney declaring that the contract is disapproved by them.
So essentially you're creating a almost like a inspection period, but for an attorney. So the attorneys get to come in and inspect the contract, and then they can cancel. So doesn't sound like this is required by Illinois law, meaning not every contract has to have it, but by
Right.
practice, the realtor association forms have this provision in there, which then allows the parties to enter into the transaction. And then, 5 days for the attorney of their choice to review it. I like that a lot. I think that's, very wise, especially in, I know you handle some creative financing transactions. We do a decent amount of it, but one of the big things, of course, that the sellers come back with, whether it, be creative finance, a wholesale transaction, et cetera, they come back with, well, I didn't understand, or I didn't this, or I didn't that. Right. And when the contract's signed at the kitchen table, or even by DocuSign, it's binding the minute that the signatures go on it. But how much more effective would the contract be if the seller had 5 days to do their own investigation to reach out to an attorney, to have the attorney review it, and then they could come back and cancel. And if they didn't cancel within those 5 days, I mean, I don't know. I mean, I think it would take a lot of wind out of the sails of a seller for uh, lack of a better word, to basically say, hey, look, you can't cancel because you had 5 days to have it reviewed by an attorney and you chose not to do that, right? I mean, it wasn't like we said, oh, you're immediately bound the minute you put your signature on it. So
It's
that's
hard to
really
claim
cool.
you didn't know what you were doing.
Right. Yeah,
Yeah,
exactly.
when you've had the opportunity to meet with a lawyer and get legal advice. I'm interested in the role that the escrow and title company play in this process. The what how does it, when you're retained by, and it sounds like you can be retained by either the buyer or the seller,
Right.
and there may be transactions where there's attorneys representing both. Um, what is the interaction between the closing attorney and the escrow company and the title company? Are they just preparing documents, holding earnest money, and waiting for review and sign off on the documents that they prepare? How does that relationship work?
So when you're representing a buyer in a transaction in Illinois, you have typically less interaction with the title company until the contract is closing. Until the closing day, you're not really communicating that much with the title company. More so, the lender in traditional deals is communicating with the title company to make sure that they have everything that they need. But I work very closely with the title companies when I'm representing the sellers in traditional transactions because firstly I order the title policy with the title company, and in turn they do the search on the property, and then they send me the search package and exam for me to go through the search package and look and see everything that's on title. So as the seller's attorney in closing, I work a lot more with the title company. I do not and I did used to hold earnest money on transactions, but I have the title companies hold the earnest money on transactions. So they're holding the earnest money as the escrow agent, and they're also preparing essentially only the title documents in Illinois. As the seller's attorney, I prepare still all of the conveyance documents. So when I say title documents, I mean they provide and they send to me the commitment, which I review, of course, after completing my exam and going through everything that's on title. But I'm the one that's preparing the deed, the bill of sale, affidavit of title, power of attorney if I'm using one in the transaction. All of those documents are prepared by me in my office. The title company will prepare, or they'll send me for execution the 1099, for example, and the documents that they need on their end to have to protect both the seller and the buyer. But the title company is essentially, and they're not there to explain the documents to the clients, which they very clearly state even on their forms. So in Illinois, I have to disclose to the buyer side that I'm working as the title agent and I'm compensated for doing the work to make sure title is clear. But I am basically doing all of the title clearance and working with the title company to make sure that we have clear title and can close. If there's something that is missed, or maybe that the title company doesn't see as an item that they need for clearance, they will like alert me to it. But I work with my seller directly to make sure that we have all items needed to clear title.
So who holds the purchase funds and who records the deed? You know, that transfer of funds going and making sure that recording is happening and everybody gets what they bargained for. Is it the title company or an escrow office, or is that your office?
Yes, that is the title company. So that's where, like I said, when I'm representing the buyer, the lender communicates with the title company to make sure that they have the information for sending the wire. And then after we close, the title company sends in the documents to be recorded. So they send in the deed and the mortgage to be recorded. But even everything as far as where there are municipality requirements, I work with my seller in my office will make sure that we meet those municipality requirements, then submit them to the title company. So in Illinois, for example, in different counties, we need maybe we need a final water bill to be able to close, or we need to have a city inspection done. We coordinate those on our end, and we just submit because the escrow agent, which is the title company, they won't be able to close. They won't, of course, insure the property without making sure these items are all checked off. So my office does the work with the municipality and anything that's on title that we need to obtain clearance for, such as a mortgage or if there are any liens or any other defects. And we just submit those over to the title company so they can see that we have it, whether it's a release, and they make sure that everything is sufficient for them to be able to give us a clear commitment to give to the buyer.
So give me an idea in terms of the timeline of the transaction. When are you traditionally brought in? Is it right at the time they have a contract and they're going into their escrow period to close? When does that typically happen?
Once a contract is executed. So like I mentioned, the attorney review period, ideally I prefer even sometimes before the contract is executed. I'm offering my services to realtors to help in even just negotiating the setup so that we don't have to make too many modifications or revisions in that 5-day period. And both parties can have some confidence that, okay, this is already a good solid deal from the start. But more traditionally, the agents have the contracts executed themselves, and then they'll make sure to get it to me right away so that I'm not already coming in at 2 or 3 days into that 5-day period, of course.
So if you've got buyers who are thinking into the future on the transaction, or the realtors thinking that as well, they can bring you on early in order to ensure that maybe some of the deal points that you would have hashed out during that 5 days, just figure them out now so the seller's not, caught by surprise after the fact, when it
Right.
feels like the deal's getting renegotiated?
Right. So I love when that happens. And I do have that opportunity sometimes. If a realtor maybe can anticipate, okay, I'm not 100% sure and I want to know before we execute and kind of give either party a false hope, can you take a look at this? Can we run these numbers? I recently had a case where a realtor was working on a net sheet for a seller and they knew they had taken out a second mortgage, for example, and they kind of want to take a look at the numbers and let's see what they are going to be profiting, if they'd be profiting at all, or if they'd be closing on a deficit, meaning they'd have to bring in money to close. Because of course that's not a deal that you want to execute if you're trying to get your seller some profit, right? So I've had that happen where they'll send me those things before and we'll be able to look at the numbers. We can see, okay, this is the cost of the title insurance at this purchase price. This is going to be the cost of this. And then I can, of course, easily throw my fee in there and we can see where the number is going to fall. And then we know, can we even accept a contract at this purchase price? Or maybe do we need to bump it to give our seller a little cushion? Or we can reach out ahead sometimes and see if we can make a payoff request. So then we kind of have those numbers in advance. Because that's another thing, of course, that I do for sellers when I represent them is we prepare the closing statement. So we're able to plug all the fees in and all of the costs, do an itemized statement and let them know this is where you're profiting. Because of course the realtors can do it preliminarily. But like I said, many of these things I need to clear title. So I have to get the exact numbers and then I can give my seller then their exact bottom line that they're getting.
An earnest money deposit question. I think I heard you mention before, it sounds like you have an option as to whether you hold the client's earnest money or whether the title company holds that. You can answer that to the extent I got that or I misunderstood you on that. But I'm curious how, in a state like yours where the buyers retained a closing attorney, how are earnest money disputes, so contract disputes over earnest money, how are those handled?
So I in Illinois at this time I am not litigating. I have some referrals if earnest money came to the point where it was needed to be litigated. But in the contract that's traditionally used, like I mentioned, the 7.0 contract, it has very, very, very strict requirements for and requirements for the escrow agent. So I don't hold anymore. I did hold earnest money in the past, but earnest money disputes have to be resolved if the parties don't agree, then it has to be resolved by litigation. And so I've found that it's best to have the title company hold. And I've heard horror stories from other attorneys where they are holding earnest money funds because they're in dispute for years while it's in litigation.
Well, that was kind of my question, because here, of course, we don't have a closing attorney. We've got the title company and the escrow office, and earnest money has been deposited into escrow, and in those escrow contracts, there's provisions that allow the escrow officer the ability to hold it pending, the parties' either agreement or a judgment from the court or whatever else. But just in thinking about that as a closing attorney, just thinking through it, I'm thinking, oh dear Lord, what would happen? How would that play out if you're holding, or if you're able to hold the escrow funds, and then there's a dispute, where you're representing one of the parties that's in the dispute, right? But the parties don't agree. I could see where that would be a nightmare for a lawyer.
Right. So like I said, I don't actively hold anymore. With the title companies holding, I find that of course, it's a lot off of my plate in that, but
Sure.
I also think there's some type of confidence that both parties have, knowing that this is not an attorney that's connected to either side. This is a third party who's holding the funds. And I found most parties don't want to, a lot of people don't want to litigate over earnest money. So I haven't had too many. I can't recall. I've had one transaction where the earnest money was in dispute, and it was actually, I found it really odd because the seller contested the loan denial letter that we sent. So in the standard contracts, the 7.0, that is a contingency in which a buyer can get out of a contract. Of course, if their loan is denied and they haven't caused this by any ill means, then they can terminate the contract and receive their earnest money. I've had one case where we essentially submitted the denial letter from the lender, but the seller disputed it. The seller disputed that it was actually a valid denial letter. So that's the only one time that I know that the earnest money was in dispute and it actually went as far as litigation. More often than not, the seller doesn't want to have the property be withheld from being relisted, and the buyer wants, always the buyer wants to get all of their money back. But if they know that maybe on their end there was, or they just don't want to continue through the fight and they don't want to put up any more money to hire an attorney to litigate, because they're trying to get their money back. So more often than not, the parties will come to an agreement and the earnest money will be released. I haven't seen it and I haven't heard it be too common that earnest money is disputed. I think that that's more of a rare occasion. Although it happens, it isn't very common.
Bree, I know that you have some knowledge on creative financing and some seller carryback transactions. Um, on a seller carryback, from a closing attorney's perspective, let's just say you represent the seller. Are you also preparing like the promissory note and the mortgage in that scenario?
Yes, for a seller carryback, since the seller is the lender in that transaction, there's no big company to prepare all of the buyer's documents. So I'm responsible for preparing the note and the mortgage to protect my seller's interests.
And then what about payment on the note? Obviously payments can be made directly to the seller as the lender, or it can go to a servicing agent. What do you see, and kind of what's your recommendation as far as, do you represent a seller, whether or not the payment should be made directly to them or to, a third party loan servicer?
I always advise my sellers to have a third party loan servicer, because I think that it takes a lot of pressure off of them. They're not having to keep accounts, having to do all of the record keeping for the payments that the buyer is making. And I think it is especially vital to have a servicing company if you're going to have an escrow. I've had situations where, a seller might say, no, I don't want to use the servicing company. They can just pay to me directly. And I think that's I'm not going to say that's okay. You can do that as a seller. Of course, it's your right, it's your choice. You can do that. And I think it's easier to do that in a situation where there is no escrow. But if you're responsible as a seller for escrowing a buyer's taxes and insurance and making sure that these taxes are paid, in Illinois, we have tax payments due twice a year. So it's the first installment for the first half of the year, second installment, but it's for the prior year because taxes are paid in arrears in Illinois. I don't want my seller, especially if it's not someone that's very sophisticated in handling these types of financing accounting records. I don't want my seller to have the pressure of making sure that these installment payments go out, making sure that the insurance is renewed annually or whenever. So I think it's best, and I always tell them, have a servicing company, very low cost to you. And even better, if I'm brought in before the contract is executed, then we can negotiate even that the buyer maybe pays the loan servicing fee. But even if
Right.
that, minimal cost to the seller, and then when the buyer wants to see their payments or they want these statements, you're not, as an individual person, responsible for having this spreadsheet or this Excel taking into account all of their payments.
Yeah, could you imagine the liability that the seller slash lender would have if they were collecting insurance payments and they failed to
Make
pay the insurance premiums and something happened, and that there was a fire or other catastrophe there on the property, or even failed to pay the taxes and you ended up with a tax lien or something like that. I mean, that'd be a nightmare. And just even without escrowing money, the idea that the seller is having to collect and account for monthly payments, apply it. Not every seller is sophisticated enough to handle that. And I've had clients who were buyers on seller carrybacks, and they ended up, back in the day, the recession period, they ended up in default on those loans. And I've represented a few of them where we've gone and asked for like reinstatements, or even payoffs, and we receive some handwritten accounting back. And it's like, I couldn't make sense of like what was owed, when payments were made, what was applied. Versus if you have a loan servicer, you go and you get a nice spreadsheet and you can really tell, okay, yeah, they received a payment on this date and they applied it to interest and then to principal and that type of thing. Yeah, when you have these individual sellers that are trying to account for, the funds, it's all easy to deal with when you're receiving the payment, putting in your bank account. But then when you're called upon to account for that money, it becomes a lot more complicated. So yeah, I think it's wise to always, have that loan servicer in place.
That's exactly what I was thinking. You're essentially shooting yourself in the foot because, like you said, say the buyer is ready to pay early, and then now it takes you a couple of days just to try to create a payoff statement because they've been making the monthly payments, but you're not sure where it's at unless you're doing this regular accounting. And I
Right.
say, if you're sophisticated in handling finances and doing that management, but even for myself, I have a bookkeeper for my firm because that's not my area of expertise and it's not something that I'd like
Right. Yeah, exactly. It would be for most lawyers, it would be a nightmare if they were responsible for that.
Now, Bree, I'm curious as to how you structure your representation of buyer or seller in these transactions and how that might differ from a typical attorney-client relationship. Do you typically bill hourly for the service? Is it done on a flat fee? How do you usually structure that?
for traditional, or are you talking about
Well,
creative?
for as a closing attorney to provide closing services.
It's a flat fee. So
So
it's a
it's
flat fee.
the work's predictable enough for you to be able to flat fee that and know that you're not gonna take a bath on it.
Right. Typically, it is. There are some cases where, for buyers more so, and this is not something that's uncommon. This is something that I hear from my colleagues all the time. For buyers in Illinois, sometimes the work can be a little more extensive because I've had deals where I might be in it for up to 2 months, and there's no fault of the buyer. There's no fault or anything that's been done on my end, but it's just the loan process, for example. So we might have to be sending out extensions, or we're communicating with the seller's attorney for a longer period of time, communicating with the client for a longer period of time. But it's it's more of like a how you structure your business and having the balance of buyer clients and seller clients, because there, like I said, there it isn't always where I'm working with the buyer for 2 months, but there are certainly those times. And then I'm looking back going, with this flat fee maybe was a little low, but you don't know when that's going to happen.
And are you paid out of closing?
Yes.
Okay, so your fee's paid out of closing. Is the buyer's attorney's fee, or maybe even the seller's fee for that matter, is that a negotiable term on the front end to decide? Like we'll have parties here that'll negotiate whether the seller or the buyer is gonna pay closing costs. Are they gonna split it? Is the seller going to do it? Maybe whether it's a buyer or seller's market is going to dictate who might pay that. Is that typically something that is negotiable as to where that comes out on the settlement statement as to who's paying for that? Or ethically there, does it always have to be the buyer? How does that work?
More commonly, each party will pay for their own attorney. It's been a few instances that I've had, and this has also been the same time where I may represent both sides. Maybe it was a deal where the buyer wanted to come and bring the terms to the seller because maybe it wasn't a property that was advertised. It wasn't something that was on the MLS. So, as a negotiating point, the buyer would say, like I'm sure you guys see in creative finance deals, I'll pay closing costs, including attorney's fees. So, it's more common that that's seen in, like I said, creative finance or off market types of deals. For traditional deals where the properties are listed on the market, more often both parties pay for their own attorneys.
Okay. What happens if during the 5-day review period the deal's pulled and there's no closing? Are you still getting your fee? Or how's that work?
So that is something that I have been, like I said, that's more of a, I guess, a business conversation. It's just, the saying like when in Rome, do as the Romans do. Most
Sure.
attorneys in Illinois, most closing attorneys get paid from closing. And so in the event that a deal falls apart, more often I just don't get paid. I've thought of, and like I said, it's more of a business structure. Perspective or choice, I guess, say, if you will, if you're going to have your client maybe pay half your fee up front. And I've heard from one of my mentors, and this is how I've considered structuring going into the new year. If they pay half up front and in that 5-day period, like you mentioned, the deal falls through, I would still allow their deposit to be applied for another transaction. Because more often than not, they want to get another house. They still want to buy. They were in the deal initially for a reason. So I say, okay, if you're still going to be on the market, still looking to buy a house, then I would just apply that deposit that you paid to your next deal. So you wouldn't
Yeah,
pay another deposit. We might have to draft another engagement agreement just to change the property address, but we wouldn't require another payment. And then
that
the other,
makes sense. Yeah, because I would think a lot of the potential clients um, may not be able to afford it without the sale of the home, right? Because they're selling it, a lot of equity's coming in, and not a lot of folks all the time are running around with enough money to hire a lawyer, but that makes a lot of sense. I wanna shift. We've been talking a little bit about creative finance, subject to transactions, and Sean, I know you're not, a closing attorney, but you do, or you're not in a closing attorney state. But you do a lot of work with creative finance transactions, and we've talked a lot about this on a lot of different shows. We think 2023 is, maybe the kind of the year of creative finance with rising interest rates and everything else. There really seems to be a lot of push behind it, and there's kind of a popularity behind it. What are some challenges that you see with whether you're in a closing state or not in closing, creative finance transactions?
Yeah, so for me, I think the biggest thing right now is the type of loan that's against the property. So a lot of title companies, closing attorneys, they will not close FHA or VA loans, um, mainly because, back 20 years ago or so, maybe longer, some title companies ended up in hot water with the FHA over closing some loans, and the FHA refused to, do business with them going forward, where they did wrap agreements, right? Wrap agreements have been around, which is, essentially a uh, subject to transaction, where the seller receives a note and deed of trust and or mortgage, and they wrap it around the existing financing so that if payment's not made, they have a remedy of foreclosure. So these title companies had done these, wrap transactions and then ended up in hot water with the FHA. And the FHA said, well, no, we're not going to, do business with you anymore because of this. And so now you have title companies who are kind of concerned about, having those types of issues come up on FHA, VA loans. Um, and so as a result, they don't close those transactions. And so that's going to be the big issue is, can someone assume an FHA loan? Sure, they're assumable, and there's a process to go through to do that. Can someone assume a VA loan? A veteran can assume another veteran's VA loan, right? So there are things that can be done. There's ways to structure those transactions. But yeah, I think one of the big issues, because I think there are a lot of FHA and VA loans out there. And so I think there's going to be a lot of investors trying to figure out, okay, how do I maneuver that? How do I still facilitate a transaction involving those loans without getting sideways with the FHA, the VA, in those transactions? And how do I protect myself if a title company is refusing to, or I can't work with a title company or closing attorney on those transactions?
What about disclosure requirements? That's got to be a new one, right? Because states are changing. We already know Arizona recently changed their laws with regard to wholesale type transactions or whatever else. But just the change in laws and contracts that are incomplete as a result of that, I think are probably going to create closing problems for the closing attorney and creative finance transactions.
Yeah, it was like what Bree was describing, which is that attorney review period. There are actual states that when you have properties that are in foreclosure, whose laws specifically say that the seller has to be given a right of rescission. There's laws that specifically say that certain disclosures have to be made to the seller for those transactions, beyond a traditional real estate contract. And so basically, what I think as creative finance becomes more and more the thing, which I think's, who knows? We don't have a crystal ball, right? We don't know what's going to happen. And so, but common sense would say, okay, we have a bunch of people out there with 2 and 3% loans, and right now you can't purchase a property for less than 5.5%, 6%, something like that. Depends, changes, weekly or daily. But that's a significant increase. And so why not look for somebody who wants to unload their property, but maybe can't find a buyer that's willing to pay what they want to pay? But you're like, oh, well, I'll pay what you want to pay, but I want your 3% loan. I want your 2% loan. And so, there are ways to structure those transactions. But these transactions are all over the nation. And so there's people who are wanting to do this creative financing, wanting to do it outside of the state they're used to normally working in, states where they've already received legal advice, who for which they've already had an attorney draft their contract, and they go into these other states thinking, well, what could go wrong? Well, what could go wrong is your contract doesn't comply with the local laws of that state, and you end up in a lot of hot water, with the attorney general in that state, or in a civil lawsuit in that state, or whatever the case may be. So I think my 2 words of wisdom would be, going forward into 2023 would be: one, wherever you're transacting business, take whatever documents you're going to use, whatever forms you plan to use in those states, and make sure that a local real estate attorney has reviewed them and signed off on them. So if you're in Illinois, go see Bree, right? And have her review those documents and make sure that they comply with Illinois law. Have them reviewed everywhere where you go. And number 2, develop good relationships with title companies and closing attorneys who can assist you in those states that you're operating, that can, give you referrals to real estate attorneys if you don't have one, if you're working with a title company, or, if you have a closing attorney, work closely with that closing attorney to make sure that, everything that you're doing is going to, keep you on the right side of the law going forward with your real estate business.
Well, Bree, thank you so much for joining us.
Thank you so much for having me.
Closing attorney, entrepreneur, mother. She found time for us. We really appreciate it. Where can our listeners find you?
You can find me. My site online is my first initial, last name Rials, Rials, lawlaw.com for my website. You can find me on Facebook at just that Bree, Bree Rials, Rials, and on Instagram, pretty the same across the board, Bree.Rials. And let me check that. I think on Instagram it's Bree.Rials.esq. You can find me there. And I haven't been too active lately on social media, as you may imagine, with baby and life changes, but definitely please follow me and be on the lookout for more content in the future coming
Yeah, no
2023.
problem. In the coming months, your social media will be filled with pictures of babies, probably, if it's anything like ours was when we had some of our first kids. Well, again, thanks, Bree, so much for being with us. Look forward to
Thanks
having you
so
again.
much.
We'll see you next time.
Thank
All
you,
right,
Bree.
thanks. You guys have a good one.
All right. With that, everybody, that is our episode for the week. Make sure to join us next week. The building blocks for a successful real estate business. Be a go giver with Brandon Simmons. We'll see you next week.
Have a good day, everyone.